Good afternoon. I am Edgar Lin, one of Wisconsin Justice Initiative's board members, and I welcome you to this virtual speaker event with Alec Karakatsanis, titled Prosecutors, Judges, and Public Defenders, the Complicity of Lawyers in the Mass Human Caging Bureaucracy. As you get settled at your screens for the event, I'm going to give my Zoom version of a flight attendant safety speech. If you are lucky enough to have avoided Zoom meetings over the course of the pandemic, here are some tips we have for you. Please be sure to mute your microphone while others are speaking so we can cut down on some background noise. Know that in the upper right corner, you should be able to choose speaker view, in which case you will see a larger picture of the person speaking, or gallery view, in which you'll see an array of the attendees. Do what feels right for you. We are recording today's events, so we prefer to see all your lovely faces during the event, but also understand if you'd like to turn your video off. And our final housekeeping point is how we will handle the question and answer session. After Alec concludes his talk, we will have those with questions ask them directly. So we don't have people trying to talk at the same time. If you have a question, you can either use the chat box and just say, I have a question, or use the raise hand function. I will then call on you and you can unmute at that time and ask your questions. If you use the chat to flag your question, please make sure that you chat to all attendees, as WJI staff will help me keep track of who is in line for questions. And now I want to extend our gratitude to our sponsors for today's event. So first, at the justice reform level, we have Birdsall, O'Bear and Associates and the Wisconsin Law Journal. We also thank our indigent defense sponsors shown on the screen, as well as our equal rights sponsors listed on the screen. In addition, numerous individuals donated to WJI in honor of this event. We thank all of them, as well as our donors throughout the year. WJI is a 501c3 nonprofit charity, and donations help WJI offer its informative blog and salon events and advocate for a more fair justice system. And now I'm going to pass the mic to WJI board member Dean Strang to introduce our speaker.
Thank you, Edgar. And good afternoon, everybody. Welcome. Thanks for joining us. You know, in maybe very late 2018 or more likely early 2019, I was sitting in my office one day minding my own business, and I came across an article at that time in the Yale Law Journal online forum written by Alec Karakatsanis. Someone whose name I had heard, but I knew very little about Alec and certainly hadn't met him at that point. The article was The Punishment Bureaucracy. I couldn't stop reading it. Once I started, I just couldn't stop reading it. I have to tell you, this hit me like a lightning bolt at the time. And within the year, Alec had followed up with his first book, Usual Cruelty, The Complicity of Lawyers in the Criminal Injustice System. It's published in the fall of 2019 by the New Press. And that's an expansion of, in many ways, some of the themes Alec developed in the earlier Yale Law Journal Forum article. You ought to get Usual Cruelty if you don't have it yet, in part because the New Press is good enough, and Alec personally is good enough to donate proceeds to purchase books for inmates and their families when we buy a copy of his book. And it's well worth reading for all kinds of reasons. And really what has struck me about Alec, whom I have since met, is that here's finally somebody who's not talking about mere reformation. He's talking about transformation, starting with abolition. in key places of our captivity and surveillance institutions that together operate as a system that we quite immodestly refer to as a criminal justice system. Alec focuses not just on the police, who rightly are getting attention, overdue attention as an institution, but he focuses as much or more on sort of the middle institutions in this line of institutions that together are an assemblage as a system. And those middle institutions, prosecutors' offices, trial courts, public defender offices, clerks of court, probation offices, appellate courts, all of those middle institutions in this system are the realm of lawyers and judges, are the realm of many of the people at this meeting today. Alec is a 2005 graduate of Yale University after having grown up in Pittsburgh, a 2008 graduate of Harvard Law School, where he was the Supreme Court editor for the Harvard Law Review. He went on to join one of the premier public defender systems in this country, Public Defender Service of Washington, D.C., and from there became an assistant federal public defender in Alabama. So he's had both state and federal indigent defense experience. And I think he'll tell you he didn't like much of what he saw. And he went on to found the Civil Rights Corps. It's based in Washington, D.C. He remains its executive director. But the Civil Rights Corps, since its inception and today, has done high impact litigation. The Civil Rights Corps has pending actions today in at least 18 states and the District of Columbia, charging or challenging bail, indigent defense delivery systems, COVID-19, and the inhumane way in which we've handled that as to people who are locked up or caged, as Alec would say. And he's got an awful lot to say. So I'm glad you joined us today. Much of what he says, although he assumes rightly all of our good faith, will make us uncomfortable. I think will challenge us to consider the lively possibility that we often are enabling and even making worse the very things that we dislike and oppose about our system. Alec will appeal to your head, your heart, and I think mostly your humanity, because he is, at the end of the day, a radical humanitarian. Please welcome Alec Karakatsanis.
Thank you so much, Dean. And Margot, were you going to say anything else, or should I take it away? Well, I want to thank Edgar for the opening and Margot for inviting me. This is, long time coming. We wanted to do this in person, and the pandemic made that impossible. And I'm really, really glad that we could do this virtual event. And hopefully, if people are interested when the world opens up again, I would love to come back to Milwaukee and talk to you all in person. Thank you, Dean, for what a remarkable introduction. I feel like it's difficult to live up to that. I'll do my best. Obviously, Dean's words mean a lot to me, coming from someone with his clarity of thinking and record of work on behalf of the most vulnerable people in our criminal punishment bureaucracy. And so I'm very grateful, Dean, for those remarks. I'm going to make it a little bit of an addendum to what Edgar said. I will talk for a little bit, but I would much rather have a dialogue with you for as much time as possible. So if at any point when I'm talking, you have a question or a comment you want to make, I would urge you to put it in the chat and we can build on a discussion from there. It's always, I think, most generative if we actually have an actual meaningful dialogue with each other rather than I come in, I just talk at you for a while. I'd love to know sort of what you're thinking about the things that I'm saying and what observations you have. I'll start by just saying I'm coming from a very particular perspective. As Dean mentioned, it's a radical perspective about what the punishment bureaucracy is doing and why. And I don't expect you to agree with everything I'm saying, and you have to understand that the things that I believe and the things that I say are coming from a very particular place, having represented very poor people who are accused of crimes, having represented the targets of police surveillance and violence for many, many years. I have a very particular vantage point on the system, and that's all I can offer you. So I just like to acknowledge before I begin just my own biases and where I'm coming from. So I hope that nonetheless, despite my biases, I have something that you might find useful to hear. I'll just start with a little bit about my background in this work, and then talk about some of the ways in which I think the current what's called the current criminal justice reform movement. Again, in the book Usual Cruelty, I explain why I don't like the term criminal justice system. I don't like conveying that either the purpose or the effect of this system is anything remotely to do with justice. But I want to talk a little bit today about why much of what's called the criminal justice reform movement is actually an attempt by powerful interests to preserve the core architecture of bureaucracy of human caging, co-opt a lot of energy that's building for transformational change. So after I left the public defender's office, I was fortunate enough to get a grant from my law school. And the grant was really open-ended. I think when I went to pitch the idea to them, I said something like, I'd like you to give me some money so I can dismantle the criminal punishment system. And they really laughed at me. But Harvard had made this big public relations push to announce that they were starting a venture fund for alumni to start nonprofits. And I don't think anybody else remotely qualified applied the first year. So they were sort of forced into this position of giving me this money to do this work, even though my pitch sounded kind of ridiculous to them. But the first thing I did with Harvard's money in the very beginning of 2014 was I went back to Alabama, and I just sat in courtroom after courtroom. I would interview people as they left court. I would interview their families. I would go up into the jail and talk to people. And I opened the first essay in the book, The Punishment Bureaucracy, with the story of my client, Charnel Mitchell. When I got to Montgomery, Alabama, where I used to live, that morning, it was a winter morning in early 2014, I saw 67 people in jail garb and jumpsuits and chains in the courtroom. As I watched, it was clear none of them were charged with a crime. All of them were Black. They were all there because they owed debts to the city of Montgomery from old traffic tickets mostly. And one by one, they got up in front of the judge and they begged the judge, Your Honor, I'm a homeless veteran. I have nowhere to go. I can't pay this money. And the judge would say, pay me, $1,000 or you're going to jail. Or I saw an older gentleman get down on his knees in court very slowly, and beg for mercy and say that he had been troubled by drug addiction for years and he wasn't trying to not pay the city. He just didn't have the resources. Another woman had 4 children at home, one of whom had a serious disability, and she couldn't afford to pay her traffic tickets for driving without insurance. So for reasons I don't usually go into and won't go into here, I was removed from the courtroom after, I guess, making a series of unauthorized objections. I don't know if it's the same in Wisconsin, but if you're not a member of the bar of a state and you're not representing anyone in court, you can't just stand up in the audience wearing a hooded sweatshirt and make objections. After I was removed from the courtroom, I went up into the local jail, which in Montgomery, as it is in many communities around this country, is both metaphorically and physically connected to the local courthouse. And I started calling out the names of the individuals who I'd seen in court before I was kicked out. And I started meeting with people and actually met with 5 people before they removed me from the jail. And the first person I met with, the person I start the punishment bureaucracy essay with, is a woman named Charnel Mitchell. And Charnel had been sitting on her couch with her 1-year-old on her lap and her 4-year-old next to her when the police raided her home violently and took her away from her children in metal chains, left her children at her house because she owed traffic tickets to the city 4 years prior. in 2010. And when I met Charnel, it had been a couple of weeks, and she had no idea where her babies were. She was desperate to figure out what had happened to them. I can't even imagine the idea of being taken away from my children because I owe debts, and then not even knowing if they were okay, not even knowing if someone from my family had picked them up, not even knowing sort of whether they were safe, whether they were getting food, whether someone was changing their diapers. And these were all the things that were going on in her mind. And she showed me her court document, and the court document said, pay us $2,807 or do 59 days in jail. And Charnel explained to me that in Montgomery, if you owed debts, you could sit out your debt at $50 a day. That's why they got the 59 days figure for her. But she told me, if you agreed to be a janitor for the city and to clean the feces and the blood and the mucus and the mold off the floors and the walls, and she was sleeping on the floor on top of a number of other women in a very small cell next to a toilet. If you agreed to clean the judge's bathroom and your own cells, you could get an extra $25 a day toward your debt. So on the back of her court document, Charnel had been doing all these frantic calculations in a pencil that one of the guards was nice enough to give her. Each day she was writing 50, 50, 75, 75, trying to figure out how many more days of work and how many more days of just sitting there it would take to work down her debt. And by the time I was done meeting with her, these calculations were just completely smudged with her tears. And nonetheless, I took a photograph of this document, and I had really no idea what I was doing. I'd never done this kind of case before, but I, wrote a complaint on behalf of Charnel and the 4 other people I met that morning, and we filed a class action civil rights lawsuit against the city of Montgomery. And within a few weeks, we got into federal court, and the federal judge, who was a former prosecutor, Republican, George W. Bush appointed judge, was so outraged at the story that was told in these documents, the court papers and the photographs and the legal arguments, that he ordered all the city officials to appear in front of him in person to explain how this could be happening. And instead of appearing in person, the city just released everybody from its jail on a single day. And that was a really powerful experience. Actually, Charnel and the other named plaintiffs, I had gotten them out of jail a couple of days before that, and so they were actually there in the courtroom that day, telling their story to the judge. And I realized a few things that day. We have become so desensitized as people who work in this bureaucracy to the incredible pain and trauma that is associated with putting a human being in a cage, separating a mother from her children, that we do it every single day, hundreds of thousands of times in assembly line fashion with great efficiency, without even understanding the brutality of it. It's normalized for us. And so much so that a major American town like Montgomery can, without a care in the world, just release everybody from its jail in a single day because it knows that it didn't have actual reasons for people to be there, because it knows that the rigorous process that a society should go in before depriving a human being of her bodily liberty it was completely missing from the punishment bureaucracy that had evolved in Montgomery. Shortly after that happened, Michael Brown was killed in Ferguson, and I read an article about that in the New York Times, and noticed that some of the same things that I'd seen in Montgomery and all throughout Alabama were also happening in the St. Louis area. And I did what I often did in those early years, and I called up the person who had been quoted in the article, and I asked if I could move into their house for a little bit. And I went to St. Louis, and I lived in this person's house, who's now become a close friend of mine, but he's the person who started this organization in St. Louis called Arch City Defenders. And I just took over a bedroom in his house and embedded myself with a lot of the people who were out in the streets every single night. And I did the same thing I did in Montgomery, and went courtroom to courtroom around the St. Louis area. And the things I saw were absolutely horrific. And I won't go into any more detail, and I promise there's a reason I'm going into so much detail about these initial stories of how we got started. But when I got there and started working with the activists and organizers who were in the streets every night in Ferguson, we found out that Ferguson averaged 3.6 arrest warrants per household when Michael Brown was killed. And the Ferguson police averaged 2.2 arrest warrants for every adult in the city. Almost all of these arrest warrants were for Black people, and almost all of them were for unpaid debt to the city. So we did something very similar. We ended up suing a number of towns in the St. Louis area, including Ferguson, a lawsuit that's actually still ongoing. And we were trying to vindicate a very simple principle. No human being should be caged because she can't make a monetary payment. And over the next few months, we brought lawsuits like this in many different places: Mississippi, Louisiana, Tennessee. In many of these places, the debt collection had been privatized to for-profit companies. So if you didn't pay them whatever the cashier told you to pay them, they would work with the local police and sheriff to have you caged. And we ended up filing a number of these lawsuits as sort of RICO enterprises against local probation departments, judges, prosecutors, public defenders' offices, cities, counties. We're having a lot of success with this because it's a concept that anyone can understand. Nobody should be put in a jail cell separated from their children because they can't make a cash payment. It occurred to me during that period, those first few months, which was really a frantic period in this work, that the same underlying flaw is really the core basis of the American money bail system. The US and the Philippines are the only two countries in the world that have a for-profit commercial bail bond industry. And so I started thinking about how to convert our legal arguments, which were mostly being brought in the post-conviction context, to challenge the ways in which local governments were collecting debts and the way they were using their police and prosecutors' offices and jails to collect and extract money from people. They've been transferring those arguments to the pretrial system. And for a variety of reasons, chose this little town of Clanton, Alabama, to bring the first challenge to the American money bail system on equal protection and due process grounds since the rise of mass incarceration. I remember very vividly going to the DOJ, the Department of Justice in Washington, D.C., shortly before filing these cases. And I had a series of fascinating conversations with them. We had this convening there. And first of all, they said, stop calling us the Department of Injustice. And then second of all, they said, you can't bring a challenge to the American money bail system effectively. I mean, we use the money bail system in 3,000 jurisdictions across the country. It's how we determine who's in 3,163 local jails. I mean, it's ubiquitous. And we had a series of discussions about whether the ubiquity of the money bail system was in fact a reason to justify it, or was actually, to the contrary, a reason why it was so problematic, and the very reason to challenge it, because of the sheer scope of the injustice, with at that time about 500,000 human beings in a jail cell at any given time, just because they couldn't make a monetary payment. So I went to the local police department in Clanton, Alabama on the morning of January 15th of 2015. And I asked them for a list of everyone they'd arrested in the last few days. And for some reason, they just gave it to me. And then I went over to the local jail and I started calling out their names. And that is when I met Christy Dawn Varney. And I talk about Christy in the introduction to Usual Cruelty a little bit. Christy had been jailed for shoplifting from a local Walmart. She had 2 young kids. She couldn't afford to pay a few $100s to get out of jail on these misdemeanor charges. And so she was separated from her children and she didn't know where they were. And like Charnel Mitchell, who I mentioned earlier, Christy was inconsolable. She was crying and screaming. The night before I got there, Christy had made so much noise and was screaming so uncontrollably about her kids that they did what they do in so many jails. They removed her from her cell and they brought her to a little nook where there's no security cameras and where they keep a restraint chair. And they strapped her into the chair and they started tasing her body over and over and over again. And the next morning I took photographs of all the taser wounds. And somehow amidst all of this, Christy looked at me and said, she wanted to do whatever it took to make sure that this didn't happen to another mother ever again. And so Christy, in a really amazing, courageous act, became the first person to challenge the equal protection and due process um, uh, sort of viability of the U.S. money bail system since the rise of mass incarceration. And we filed her case that night. I sort of, inputted her information into a template I'd already drafted, zoomed back to the courthouse, got it filed a few minutes before the courthouse closed. And within a few weeks, the DOJ itself had filed a brief in our case supporting us. What had been a sort of outlandish, wacky theory was now the official position of the U.S. government. In the first 10 months of 2015, we brought 12 of these lawsuits in 12 different cities around the country. And then slowly we started expanding our work and making challenges across the country, leading to some of the bigger victories that have gotten much more media attention, like the one that we won, striking down the money bail system in Houston, Texas, which is going to get about 18 or 19,000 people out of jail every single year in Houston. Challenges striking down the money bail system in New Orleans, Chicago, a recent case striking down the money bail system in California, in the California Supreme Court, similar victory in the Nevada Supreme Court, and dozens of other places around the country. And so that's a little window into how we got started doing this work. What led me to write the book, and as Dean mentioned, there's so many things that we could talk about. But what led me to write the book is after working for 4 or 5 years in the sort of civil rights space and 4 or 5 years in the public defender world, I began to be extremely worried about not only the role of lawyers like myself in perpetuating legitimacy of all these institutions. So, for example, I began to feel as a public defender that my role in plea bargaining and snitching and standing there with my clients and making very tough judgment calls about which arguments to make and which arguments not to make, and was really legitimating the assembly line bureaucracy of the criminal punishment system. I can talk about that a little bit more later. But I felt the same way as a civil rights lawyer in some respect, because even though we set out to do civil rights work in a different way, to work with journalists and artists and poets and organizers and advocates and community, and to try to contribute to a movement, there was something about the use of the court system to vindicate people's basic rights that seemed to legitimate that system. Coming to that system and pretending as if it was a venue for justice, when for several hundred years, the court system has been a venue for people who own things to protect those things, right? It's always served the interests of a wealthy and powerful elite. It's the same court system that supported and provided the infrastructure to accomplish the theft of indigenous lands and the massacre of indigenous people. The same court system that accomplished the ownership of human beings during slavery, the same court system that promoted the system of convict leasing and racial terror in the post-Reconstruction era. It's the same court system that denied equal rights to women, and so on and so forth. And somehow, bringing these court cases had the danger of legitimating. And what I saw in the years, in sort of the first few years of doing this work on a national scale as a civil rights organization, as I saw a very sophisticated response from the elites who control the criminal punishment bureaucracy to calls for reform. And in many cases, the kinds of reforms they were promoting would not dramatically shrink the size and power of this punishment bureaucracy, a bureaucracy that today is 5 to 10 times larger than it was 40 years ago per capita, a bureaucracy that is 5 to 10 times larger than any comparably wealthy country, a bureaucracy that cages Black people at a rate 6 times out of South Africa at the height of apartheid. When you look at the kinds of things that are being offered as reforms, they simply don't meet the scope of the injustice and the harm and the violence that this bureaucracy is perpetrating. So what do I mean by that? Well, let's just take bail as an example. There was an effort, largely actually led by lawyerly elites in the 1960s and 1970s. Really, Bobby Kennedy spearheaded it and then was taken over by a number of judges and prosecutors, and eventually culminating in the Federal Bail Reform Act of 1984. And actually, last time I was in Milwaukee speaking to the 7th Circuit Judicial Conference, one of the magistrate judges made a really interesting presentation. And the magistrate judge said, when we passed the Bail Reform Act, and I've since verified all these numbers to include it in my book, when we passed the Bail Reform Act, detention was of people who couldn't afford to pay their money bail pre-trial was 24%. It was a big problem. About a quarter of all presumptively innocent people in federal courts around the country were detained prior to their conviction because they couldn't pay money bail. But today, after the 1984 Act eliminated wealth-based detention and constituted one of the most important and profound liberal reforms of the criminal punishment system, the detention rate in federal court is 72.4%. So we did bail reform, but we tripled detention rates. And if you look at who's detained now, people are more disproportionately poor and more disproportionately Black, more disproportionately immigrant than they were in 1984. So over 30 years later, we tried to address a harm and we made the harm at least 3 times worse. If you look across the criminal punishment system, across reforms, to the newest, kids on the block, what Michelle Alexander calls the newest Jim Crow, the rise of e-carceration, electronic monitoring, right? In Chicago, after our lawsuit, the jail population went down 40%. The budget of the sheriff's office went up 28%. Thousands of people were put on electronic home monitoring confinement, disproportionately Black, disproportionately immigrant, almost all poor. Huge multi-billion-dollar companies coming in, investing in electronic monitoring, drug testing, for-profit surveillance and supervision. I can go into this more, but you get the gist. Is basically these systems of oppression, if left to their own devices, will reproduce themselves. It's similar to the idea that you could end racial segregation in schooling through a Supreme Court decision, right? If you look at school segregation prior to Brown versus Board of Education, it's actually worse by some metrics in much of the country now than it was before Brown. And that is because if you don't attack the underlying balance of power, the sort of wealthy interests who control these punishment bureaucracies and the sort of logic of bureaucracies generally, they will find ways of reproducing the same outcomes with different labels. So what we have now around the country is everyone, including people who used the cash bail system for decades as prosecutors, as judges, they're now calling themselves bail reformers. But if you look at what they're proposing, like the new law that we were thankfully able to defeat at the ballot box that California Democrats passed, it was a dramatic expansion of pretrial detention, just like the federal system. It was a dramatic expansion of electronic monitoring and surveillance. And so the company that used to sell you your bail bond, and I know you don't have for-profit bail bonds in Wisconsin, but the company that used to sell you a bail bond is now in California going to be the one that sells you a drug test and sells you an electronic monitoring device for $12 a day. We have to understand how this works. I'll give one more example, and then I'll answer the question that's in the chat. One more example of this phenomenon that I think is widely misunderstood now are these discussions of spending more money on police training and body cameras. What a lot of people don't understand is that extra money for equipment and technology and training and body cameras was actually a goal of police departments and police unions for many, many years. What they couldn't do is get billions of dollars in funding that it would take to, say, for example, outfit every cop in the country with a body camera. So what do they do at very high levels? The police bureaucracy realized they could use their own violence and brutality as a way of allying with liberal, quote unquote, reformers in local governments to actually get the appropriations they needed to outfit everyone with body cameras. So why do police want body cameras so much? Well, the police control the camera. It's outward looking. It is incredibly useful for evidence used largely against poor people and people of color. Very, very rarely is a body camera ever used against police officers, right? Moreover, police officers know that even if something bad shows up on the body camera, the chances of it ever resulting in any kind of harm to them are very, very low. But most important, body cameras are a linchpin of the new surveillance objectives of police departments. They view them as a new mobile surveillance tool that can be linked to sort of hardwired security cameras that they're increasingly outfitting around cities. Many of them privately owned and connected through networks like Amazon Ring to police databases, but also connecting to new facial recognition software databases that police departments and federal agencies are working with companies like Palantir and Amazon and Microsoft to sort of make ubiquitous. This is really the true goal of the body camera from police perspective of the body camera phrase. And yet, liberal reformers made body cameras the main reform they pushed for after the murder of Michael Brown. We need to understand the ways in which our advocacy of certain reforms furthers the size and power and control and discretion of the very bureaucracy that is an assembly line efficiency mechanism for caging and surveilling for communities and people of color. So I have a lot more to say about that, but I'm just going to look at the question in the chat, if that's okay, and try to answer it. So the question was, has anyone figured out a rough estimate of the monetary cost of incidental collecting for debts, foster care, lost jobs, welfare? There have been some attempts to quantify it, the costs of this, and they're astronomical, obviously, as you mentioned. There's been some studies that show that if you jail someone for just 48 to 72 hours, you make them more likely to commit crime in the future because you take them off their medication, you maybe lose their bed in the shelter, you separate them from their kids. Most people who have working class jobs in this country can't afford to just be MIA from their job for 48 to 72 hours, so they lose their job, which is a huge driver of further arrests. So there is some literature out there attempting to quantify it, but in my view, none of it is all that comprehensive. It's very, very difficult to quantify all of the social costs of this, but there are some scholars who are attempting to do this around the country. There's a sociologist named Alexis Harris who's been doing some of the main work on that issue. Next question was, what do you think of the argument that cameras are better at traffic enforcement and that cops should get out of the business? So I definitely think police should be out of every business, including traffic enforcement. There's really no need to enforce traffic laws with violence and weaponry. I don't have really an opinion on traffic cameras. I haven't studied the issue all that closely. They mostly seem to be a revenue generating source for local governments, and I'm not aware of any evidence or research that shows that they're actually effective sort of public safety mechanisms. But I think a much more profound question is sort of, how do we design our cities and our public spaces and our transportation for overall health and wellness? One of the things that I write about a lot in the book, in addition to giving hundreds more examples and to giving you a rubric for how you can evaluate whether a reform is pro-carceral or anti-carceral, right? One of the things I talk about in the book is we have a really warped understanding of social harm. Traffic is one of the examples that I give. The way we use cars and the way we sort of regulate traffic causes enormous death, suffering, and injury that's easily preventable. It has to do with the way we've designed our cities, the kinds of cars we design and how we design them, environmental pollution. Many, many more people die from air pollution every single year than all forms of violent crime combined, right? The kinds of things that we think of as violent and harmful and as issues of public safety are things that the people who benefit, the people who own things, the wealthy elite who control the criminal punishment system, have actually trained us to think of public safety in a very, very narrow way, as sort of like solely having to do with what they call violent crime, right? This is the propaganda that we're given, even though, as many of you probably know, only 4% of all of what police do has to do with what they call violent crime. Again, I think the word violence is really misused. Is it violent to poison children's water with lead, right? Is it violent to require people to work in workplaces where they're going to consume secondhand smoke, knowing that 450,000 Americans die every year from secondhand smoke and tobacco smoke alone? Sorry, 450,000 from tobacco and 45,000 people from secondhand smoke alone. So part of what I'm urging in the book is a massive reconceptualization of what it means to be safe and healthy and flourishing in our communities. And I think that would see massive resource shifts away from the punishment bureaucracy and toward investments in the kinds of things that make people safe and well. So in terms of traffic enforcement, I think replacing cops with cameras is just the tip of the iceberg. We need to do some, and people have done this research. There are many brilliant sort of urban planning scholars and organizers and activists who are thinking about how we design cities and roads and bicycle paths and pedestrian lanes to massively reduce the number of fatalities and injuries that result from our current system of traffic enforcement, and to shift transportation patterns. And part of what people mean by abolition is not like preserving our current world and just removing all the jails and police officers. That wouldn't work because our current world is so unequal. It has so much trauma. So many people are being traumatized and abused and harmed every single day that we don't have the kinds of relationships and support systems in place to protect people. Part of what abolition is envisioning radically different ideas of human connection, different public spaces, different ways of promoting poetry and theater and music and art and athletics programs for children, different ways of living together in affordable communal places, right? This is sort of the bolder vision of abolition. Now, I think you need not go anywhere close to where I've just sketched out, which is kind of radical, right? To understand that the vast bulk of our punishment bureaucracy is just causing harm. So we could all agree not to touch anything with violent crime and not to dramatically change our society, and we could reduce our punishment bureaucracy about 80% and look like the kind of society we looked like 40 years ago, look like what England or France or Germany or Canada or Mexico or Japan or most Latin American and African countries look like in terms of the levels of human caging. So I don't want you to think that in order to agree with some of what I'm saying, you have to agree with the more radical ideas that I'm articulating. But I'm just trying to introduce you a little bit to some of the concepts and what it might mean to really think about public safety. Because keep in mind, there is so much crime in our society that police don't even respond to, right? The vast majority of violent crime, of intimate partner violence, of child sexual abuse never gets reported to police. These are harms that are occurring that are the result of drug addiction, lack of relationship to each other, lack of human connection, poverty, toxic masculinity. These are the causes of gender-based violence. These are the causes of much of the property crime that currently exists in our society. And it's funny to me that the criminal punishment bureaucracy is not addressing itself at all to those underlying causes. And so one of the ideas about abolition is we will address not only the harm that's currently being brought into the criminal punishment system through these transformative and restorative processes, but we will also reduce all of the harm that is not even being brought into the criminal punishment system. I'm going to pause again. There's a couple of questions that have been submitted in the chat. Yikes, not to sound overly defensive, but I'm trying to be real. Are we all just doing this wrong? Will you be able to give us all jobs starting nonprofits? Or, basically sort of what do we do as criminal defense lawyers? So I'm giving like a broad overview, but I also spend a lot of time. I am very fond of and very close with much of the public defender community around the country and private criminal defense bar. And I spend a lot of my time doing workshops and trainings. I do specific trainings on prosecutor misconduct and Brady. We have a whole set of lawsuits in our organization suing prosecutors. We have a whole project to do bar complaints against prosecutors. We have a whole set of trainings about how criminal defense lawyers can operate. I have a separate set of trainings about sentencing and bail for criminal defense lawyers. I'll just say a couple of things about that since you asked. But one of the main things I urge criminal defense lawyers and solo practitioners and others to do is ally yourself with people in your community who are organizing, who are building a movement. Figure out how your unique set of skills can be helpful, right? What we're setting up in a lot of these places is participatory defense hubs that work with people's families and are a liaison between organizing families and criminal defense lawyers. So a criminal defense lawyer comes into a bail hearing with 7 or 8 people in the audience, 3 or 4 witnesses to call, a whole life history, a story they can tell about the person. All of a sudden, what used to be a 30-second or 1-minute hearing about what amount of money was going to be charged is now a conversation about the person's family and children and employer and what the consequences would be if the family was separated from their children pre-trial. And that family is now politicized and mobilized because they're meeting other families whose loved ones are going through bail hearings. We're helping criminal defense lawyers reconceptualize the nature of their practice. One thing we did when I was in the federal defender's office was me and a colleague of mine were basically in charge of all of what's called the illegal reentry cases in our jurisdiction. This is a euphemism that federal courts use for putting a human being in a cage when that human being was born in, on the wrong side of an imaginary political boundary between 2 countries, and then came to this country. That's a federal felony crime if you re-enter the country after having been deported. And when we started doing this work, the judges in Alabama were giving really long sentences for this, supposed crime. And keep in mind, these are all people whose only crime was walking across an imaginary political boundary that had been set through colonial conquest between this country and Mexico. And in many cases, this crime was so that they could provide for their families. So what do? We would do very basic things in the courtroom. We'd come in and say, Your Honor, I'm asking you to order the U.S. Marshals to unshackle my client so that she can hug her child one last time before she's deported. All of a sudden, like the emotional tenor of the room is not about punishing this person. It's about whether or not the judge is going to use his or her power to allow a mother to hug a child, right? We would have our clients produce artwork in the jail, and we would explain the artwork at sentencing. The client would explain the artistic choices. Well, why did you make the house this color? And why is your daughter's dress looking like this? And how did you decide to put that kind of tree in here and not a different kind of tree? And all of a sudden, we're having a conversation about a human being who has thoughts and dreams and love and family and visions and creativity. And we're not talking about an illegal alien who's trying to come hurt this country, right? Another thing that my colleague had this brilliant idea on is for every single client, every single case, we have a section of our brief where we explain to the judge the history of U.S. intervention in that particular Latin American country, right? Explain how actually the harms that our client is fleeing, the right-wing death squads, the sort of military police, they were all trained in the U.S. They were the result of U.S. training of those paramilitary forces. They were a result of American intervention. They were a result of U.S. Assassination of democratically elected leaders. And I have to say, I'm not saying that every single judge in every single moment will all of a sudden have a light bulb go off. But over the course of months, all of the sentences started going down across the board. Judges were thinking about the crime of illegal reentry in a really different way. So all over the country, we're thinking with public defenders and criminal defense lawyers. When I was at PDS, for example, we had a hard and fast rule: no talking to the media, right? The media are the ones who destroy our clients. They have sensationalized stories about them. But now, all over the country, not only are we working with public defenders about building relationships with organizers, changing their in-courtroom advocacy to better disrupt the system, but we're also talking to them about how do you work with journalists, artists, to tell these stories in different ways. So at Civil Rights Corps, we have an artist in residence and a poet in residence and a musician in residence, right? The idea is to help our lawyers think differently about how to tell these stories, how to frame these harms. But we also, work very closely with public defenders and journalists around the country to tell a really different story about the criminal system. For too long, we have ceded the narrative about the criminal system to police reports. And police reports have something very particular about them. They're designed to erase the humanity from a situation. They're bureaucratic. They're about names, numbers, dates, locations. I mean, most of you have probably read police reports. They erase all of the context and humanity from a situation. Poems are exactly the opposite. Novels are exactly the opposite. They are about building connection between two human beings so they can understand each other better. They can understand each other's hopes and dreams and fears. Police reports are about erecting an impenetrable wall between two people. You cannot understand this person. They are all their humanity has been stripped from the situation. All you can see is the criminal act they committed. And so, you ask about criminal defense lawyers, have we been doing it all wrong? Yes, I think we have, in many respects, been doing it all wrong. But I don't think the solution is, as you sort of, I think, sarcastically and I think very appropriately suggest. I don't think the solution is starting nonprofits or competing for foundation dollars. I think the question is, how can we, in each of our small local neighborhoods and communities, build connection with other people, organize families who are impacted, support them in their work. In the first essay in the book, I try to highlight some things that I think of as particularly promising. So, for example, tenant organizing, community land trusts, worker-owned co-ops. One of the things they did in Cleveland, which is really exciting, is people talk about reentry a lot, but most of the reentry programming in many of these places is designed to funnel people while they're on highly intrusive probation or parole supervision into low-wage, minimum wage jobs. But like one of the things that we have to realize is that in most of these major cities that are controlled by liberal, so-called reformist, Democrat governments, they are the largest purchaser of things like landscaping, laundry, cleaning, utilities. So what they did in Cleveland is they started a worker-owned co-op designed to prioritize hiring people who are formerly incarcerated or from heavily policed neighborhoods, and to get contracts for that the city instead of subsidizing and funding Aramark and all these large multinational corporations through the food service, you fund the community-based companies that are owned by people who've been incarcerated. And you're building economic capital and political power at the same time. You're building connections between people. You're building investment that people feel in sort of their own power. So I'm a big fan of worker-owned co-ops, sort of a different model of economic organization. I'm also a really, really big fan of a number of just restorative and transformative practices that shrink the power and size of police and prosecutors to deal with harm. These are sort of systems that are like one-way ratchets. Like if you ratchet them up, they have more power and money, and then they can spew that money and power across the local political system and prevent changes. But if you reduce their size and power, if you reduce the number of police officers, if you reduce the police budget, that next year they're a little bit less powerful, right? And so I try to talk in the book about some things that ordinary people can get involved with and do. But it's actually on my list. I'm glad you asked that question. It's on my list to write a new essay that is more specific and more particular about how to get involved. But if you follow Mariam Kaba on Twitter, her handle is Prison Culture. She's constantly posting ways in which you can get involved. She has a really great website called transformharm.org and interruptingcriminalization.org. They all have like really good examples. And then the other thing I'll say to get involved locally is, how can you as a criminal defense lawyer and as a legal aid lawyer, as a other kind of lawyer, as a non-lawyer, how do you get involved? Well, there's mutual aid groups that are forming in all of these places that actually build solidarity and not charity. I think the difference between solidarity and charity is very, very important. There's building power, community bail funds, court watch programs. These are all things you can get involved with. So my mother retired recently and joined the local court watch program in Pittsburgh. And so now my mom is a part of a group of people organizing to hold the judges in Pittsburgh accountable and to report to the media, to public defenders, to other people what they see in court every single day at bail hearing. I'm going to just pause there for a second to see if there are other questions while I take a quick sip of water. Okay, I will answer one of the questions that Dean had brought to me earlier. Then, since I don't see any. Oh wait, I'm sorry, I missed the question. I apologize. Nick, the problem with traffic cams versus civil is it contributes to mass surveillance and nuance in the police state. Yeah, exactly. So another piece of skepticism I have about traffic cameras is exactly what Nick mentions. It again plugs into the ever increasing role of surveillance state. And frankly, I think a lot of these problems can be solved by sort of bold, innovative thinking that goes well beyond the confines of police and the sort of enforcement mentality. The idea that to get people to abide by rules, we need like some kind of enforcement, is I think really belied by world history, and the ways in which societies craft mechanisms of accountability and connection and relationship. And so I very, very much believe that we don't need to think about every kind of rule in our society as something that needs to be enforced all the time with kind of threat of state violence or punishment. Okay, there's Peter's question. Does any state allow former offender co-ops to go into the prisons to begin to train inmates to join reentering the community? I have not done a 50-state survey on this, Peter, but my understanding is that this is the kind of thing that is allowed in every state. There's no law that I've ever seen that would prohibit this. One of the things that you run into is a lot of state prison systems are very controlling about who gets in regardless, and who can visit people and what. So I've seen success of some of these things, like going in as like religious congregations, sometimes get less scrutiny. But no, there's really no reason why people couldn't start something like this right away. There are lots of job training programs in prison, but they're just not focused on power building. They're not focused on building economic capital. They're focused on training people to do very particular tasks that are very useful for people who own things in our society. And they're not focused on sort of wealth redistribution through worker-owned cooperatives. So I'm not aware of any law that prevents it. In fact, a lot of business groups and others go, in fact, and do this kind of training, but it has a different focus. And most states and the federal government use their sort of quote unquote small business funds in ways that are, either leaving huge pots of money unclaimed, or privileging and prioritizing certain types of small businesses. They could actually focus on, as a form of reparations, they could focus on investing in small businesses that are owned and operated by formerly incarcerated people. One of the things that I talk about, a little bit in the book is just mentioned as an example is like, as more and more states are legalizing marijuana, one idea is to set up co-ops that are owned by people who've been targeted by the police, people who've been formerly incarcerated for drug crimes, right? Instead of having people like John Boehner, who's now one of the big investors in the marijuana industry, instead of having large, sort of wealthy white people come in now that marijuana is legal and make billions of dollars off of it, this could be a way in which the system actually looks back and is able to accomplish some form of reparation. I see, Peter, did you ask a question earlier that I missed? I feel like okay, sorry, I got to it. I think Gretchen had a question. Any thoughts on the new Supreme Court decision on juvenile left parole? How would you fix the court if you think it's broken? So that's a really great question. Let me just say a couple of things. I would never, and I talk about this also in the book, I would never call the court system broken, or the criminal punishment bureaucracy broken. I think the system is working exactly as it was intended to work. Now, if you think that the goal of the system is to lead to a society where there's all this equality, there's racial justice, there's gender justice, there's human flourishing, people aren't starving, people are safe and healthy and able to pursue the kind of life that they want for themselves and their families and their children, then yes, the system is a complete failure. It's incredibly broken. But if you think that the goal of the system is to control and surveil and brutalize a certain segment of our population, and to preserve the wealth and power hierarchy that is controlled by people who own things in our society for the last several hundred years, then actually the system is working incredibly well. So to say the Supreme Court is broken, I think you have to ask a question of, well, what is the purpose of the Supreme Court as an institution? What was the purpose of the court when it held that Black people could be property? What is the purpose of the court when it tolerated the theft of land and the massacres of indigenous people? What was the purpose of the court when it said, one of the things I did in law school is I did an analysis of the first 70 years of the 14th Amendment. And remember, this was an amendment that was written for Black people. The stated goals of it had to do with preventing the sort of reestablishment of slavery or slavery-like systems, with basic human and civil rights for newly liberated people in the South. In the first 70 years of the 14th Amendment, almost every single case using the amendment to strike down a state law or practice was on behalf of a corporation. The vast plurality of them on behalf of the newly burgeoning railroad industry. Only 9 cases to the Supreme Court in the first 70 years ruled in favor of Black people under the 14th Amendment. 7 of those 9 cases were a very esoteric, discrete issue about jury selection, right? None of the cases ruled in favor of women. So I think, you have to ask, you have to start, I know I'm sort of beating around the bush here, Gretchen, I promise I'm getting to something useful, but I think you have to have a really deep historical understanding of what these institutions are. Another book that I recommend a great deal is called Our Enemies in Blue, which is a history of US police force and US police bureaucracies from their establishment as sort of former slave patrols in the South and as union and labor busting institutions in the North. And sort of how the police sort of bureaucracy morphed from a tool of sort of political machine politics to crush labor uprisings and other sort of immigrant revolts in the early 20th century to now what we've been seeing in the last 40, 45, 50 years as a sort of a professionalized force that markets itself as one that's concerned with this new sort of propagandistic notion of public safety. Police have never been concerned with the public safety, right? And I think it's a very important point to make. And the same thing is true of the US Supreme Court. I recently did a podcast called the 5-4 podcast. And I was invited onto the podcast to discuss. It's a really fascinating discussion. I highly recommend listening to it if you're interested. They're a very funny podcast, but they discuss bad Supreme Court cases. And we discussed this case called San Antonio versus Rodriguez, which many of you probably know, which has come to stand for the proposition that poverty is not a suspect class. And we engage in a lengthy discussion in the podcast about how to view the Supreme Court. So I think what we're seeing now with the recent Supreme Court decision last week is a new boldness on the right. For many, many years, we've seen a Supreme Court that is really constrained by a certain need for legitimacy among sort of the mainstream of American society. So the court is very reactive, right? The court does things that are mostly in line with sort of median sensibilities of the general public. It knows that it'll start to lose legitimacy if it goes too far beyond that. And so we've sort of had like a sort of a moderate conservative court for the last 40 years that has sort of been promoting a sort of quasi-fascist agenda, but in a way that sort of dresses things up in a liberal rhetoric. And so, I talk a lot in the book about how the court has been really successful at creating this facade of we have really nice values on the front of the Supreme Court: equal justice under law. Our legal monuments often say really nice things. Our constitutional scrolls are very nice, but the court has tolerated and been very sophisticated about creating an incredible gap between the way the law is written about and the way the law is lived and experienced. And a lot of our civil rights work for the last 30 or 40 years has been exposing that gap and forcing the legal system to confront that gap and to close that gap to preserve its own legitimacy. I think that is a lot of what was going on in the same-sex marriage cases, for example. So in the early 80s, a lot of very smart, fancy lawyers brought these same-sex marriage cases around the country. They basically lost in every single court they entered into, including the US Supreme Court. And 25 years later, some of the very same lawyers with the very same arguments, right? The same 6 or 7 words in the 14th Amendment brought those same cases, and they won in every court. And they won in the US Supreme Court. Now, what happened? Did those lawyers become smarter? Did the Supreme Court become a more just institution that cared more about the rights of the LGBTQ community? Absolutely not. What happened was there was a social movement that changed the balance of power in our society, that changed the way we think about same-sex marriage. And the court reacted to that. And so that's why I always come back to, we need a social movement that changes the way we think about human cages. It changes the way we think about the purpose of police, prosecutors, surveillance, control, punishment, pain. That changes like how we relate to each other. And if we do those things, institutions like the Supreme Court will follow. One of the scary things, though, is I think it's much easier to do those things in a society that is formally committed to sort of certain liberal values. What I see increasingly in the courts, particularly the circuit courts, like the Fifth Circuit, where I have a case coming up on the constitutionality of bail en banc argument in a few weeks. Now 40% appointed by President Trump's appointees. We are seeing a sort of a new, overtly fascist sort of right-wing takeover of the judiciary. Many of the circuit courts are more right-wing than the U.S. Supreme Court. And what you saw in the juvenile life without parole cases was a court that is increasingly less committed, just like the rest of the federal judiciary and like the Wisconsin Supreme Court in many respects, a court that is less committed to even overt lip service to liberal values and is more and more willing to be overtly fascist. That's a scary development because at least in a liberal society that is making some attempt and it feels some obligation to narrow the gap between its stated values and its actual outcomes for people's lives, that's not true in a fascist society. And I think we should be very alarmed by decisions like the one the Supreme Court just issued because they're so dishonest. They're overtly rejecting any connection to logic or reason or precedent. And I think, Gretchen, that's a very scary development. And luckily, in some respects for us, I think the only way to fight back against that is really the same basic core thing that I keep coming back to that we use to fight against the sort of neoliberal, capitalist, white supremacist society that we already have, which is organizing, which is getting together other people in your community, in your circles, building power, building bonds. I mean, one of the big projects of our punishment system and our capitalist marketing society more generally over the last 50 or 75 years really has been to isolate and alienate people from each other, to put people more and more in atomized units or individual family units, to break a lot of the civil society connections that people had in groups with each other, because people are a lot easier to control if they're not coming together and organizing naturally in groups. And I think that is one of the profound goals of the punishment bureaucracy, is to fragment and make more desperate and isolated large segments of the working class society, and particularly Black people. It was a way of crushing Black organizing resistance after the establishment was pretty scared by the rise of Black power movements in the 60s and 70s. And that's why you saw it become the #1 priority of the FBI to destroy the Black Panther breakfast program. Did the FBI care that much about whether children in poor communities were getting free breakfast? No. But did they care about sort of a growing effort to build solidarity, political solidarity, economic solidarity in the Black community? Yes, that was a huge threat. I'm going to just pause for another second because I've been rambling more than I had intended, and I hope someone else has a question.
So, Alec, I've been so enthralled with the talk, I forgot to MC. Anybody else have any questions? We've got a couple more minutes. How about Katrina? Or Ben has a question.
Hello. I have been organizing as an abolitionist here in Wisconsin for a few years now, and as a prisoner advocate as well. And I wonder if Alec has any advice on how we can better connect the legal scholars inside with lawyers on the outside, and with the kind of resources that you all are able to leverage.
Yeah, thank you, Ben. That's such an important question. I think in my experience, and I'd be curious to know if your experience in Wisconsin is different, there is tremendous interest on the inside in having these connections and building these relationships. And honestly, very little interest in the outside legal community in most of these places. I'm talking about law professors, legal clinics, law firms, solo practitioners, and public defender offices. That's part of what I mean by our complicity. As a lot of these liberal lawyers on the outside, like many of them that I talk to around the country, they do not have a theory of change. They do not have a real theory for how transformative social change will happen. As a result, they end up supporting a lot of these sort of liberal reforms that are not designed to radically change the way our society looks, but that are designed to maybe shave off some of its most grotesque flourishes and preserve the architecture of this bureaucracy. And so what we desperately need, organizers like you, abolitionists, to do political education work with local lawyer groups, help people understand that the kinds of changes that they say that they want in our society are never going to happen as long as we're talking about better training for the cops and like body cameras and whatever other substitute whatever other moderate liberal reform you want in the criminal system or in the housing system or the foster care system or the immigration system, right? We need to be challenging the underlying logic of all these systems, and to do that, they need to be building alliances and relationships with the working class people who are the sort of main target of these systems, and they need to be in service of those people. And so, I find book clubs, reading groups, bringing people in and having them listen to people on the inside. That's one of the reasons why I think mutual aid groups are just so profoundly important. When you start working in a mutual aid group, you start building connections with your neighbors. You start building connections with the people who you're sort of organizing with. And so I try to encourage lawyers to get involved in as many efforts like that as possible. And I don't know what more to say other than like we have to organize and do deep political education for liberal lawyers. Sorry, go ahead. Will you say a follow-up?
Yeah, so I guess I want to kind of drop a couple local projects. This Sunday, there's a mutual aid like resource distribution that's going to be in Washington Park, right?
No, it's at the Mitchell Park Domes.
Mitchell Park Domes. So that's something that the people on the call could be involved in. I mean,
they're going to be giving out 500 boxes of food to families on the south side who need a lot of help with legal issues.
Yeah, and then on a more like prisoner-focused mutual aid project, well, I volunteer with FFUP, Forum for Understanding Prisons. We have a lot of incarcerated litigators who are always looking for help, and if anybody on this call is able to do any legal work, please hit up FFUP. But we also have a project sending reading materials into prisons and getting prisoner voices out and trying to build, like you were talking about, like almost like a book club across the fences, and that's called Milwaukee Lit Supply. So I don't know, I just want to kind of drop those things. Thank you.
Thank you for that, Ben. I have a question from Katrina Rhodes, and I'll just read it. Alec, how would you get buy-in for your ideas from crime victims in the larger society?
This is such an important question. Thank you, Katrina, for asking it. Absolutely vital. One of the most shocking and profoundly ugly aspects of the rise of mass human caging has been the co-optation of what are referred to as crime victims by prosecutors and police. I don't think anybody believes, and there's certainly no evidence to suggest that the path toward a society with less harm and less victimization is carceral. There's a really good new book out by a professor named Aya Gruber, Gruber. I think it's called something like The Feminist War on Crime or something like that, that goes into this in the context of domestic violence. There's also another book called by a professor named Lee Goodmark, Goodmark, about sort of carceral responses to domestic violence. But it's obviously much broader than the domestic violence world. And this is why I think that the website I mentioned before, transformharm.org, is such an amazing resource. There's podcasts, videos, articles, resources there about, mainly curated by people who've been victimized by crime, about how the existing carceral approach to crime does not make people safe. This is a really important, there's sort of the visionary work of restorative justice people like Sujatha Baliga, a victim of sexual violence herself, by Danielle Sered, who was both a victim and a perpetrator of harm by sort of her own telling, who wrote a book called Until We Reckon. So these are all people who, who identify as survivors of violent crime, who are putting forward profoundly inspiring and ideas that have a much better statistical and empirical track record than criminal punishment. So, I think the other thing to keep in mind is that, a few years ago, there was this fascinating story about how prosecutors in California controlled this victim reparations fund. And they excluded from this fund any crime victim who themselves had a criminal conviction. And I thought that was a profoundly telling commentary on the sort of who prosecutors are and what they do and what role they play in the system. Because many people who are caught up in our criminal system, who are accused of crime, have themselves survived horrific violence, neglect, and crime. And the line between the so-called crime victim and the so-called crime perpetrator does not exist in our society. And we need a much more communitarian sort of outlook, sort of based in solidarity, based in a desire to actively confront harm. Another resource I'll recommend is there's an amazing free documentary you can watch on CNN.com called The Feminist on Cell Block Y. And this is about a program started by a friend of mine named Richie when he was in prison in California. And he spent years organizing people in prison with him around toxic masculinity and doing workshops to confront it. Many of the people in the program were the perpetrators of violence, but also were the victims of violence. And this documentary just beautifully talks about that tension. And Richie is just one of the most charismatic and brilliant people I've ever come across. And this documentary is very short, it's like 40 minutes long, makes great for sharing with people. But it's a really abolitionist vision, because the idea is we don't need to incarcerate and further traumatize people, expose them to more violence in prison. What we need to do is address the underlying causes of harm when people harm each other. And so all the people that go through his program, then become facilitators for the next year's program. When they get out of prison, now that Richie is out, he hires them, and they start these programs in other places. So, I mean, I think we need, and there are organizations that are organizing survivors of crime all over the country. We're organizing them for non-carceral approaches. And so I think the answer to your question, as always, is we organize people. We organize people who have experienced violence. This is one thing that the Movement for Black Lives has done really, really well with the unveiling of their federal Breathe Act. It engaged survivors of violence all over the country and sort of helped figure out what would be a bold, visionary platform federally for addressing the system of mass incarceration that has the support of people who've been victimized by crime. I'll just stop there because I want to make sure we have time for another question.
Do we have any more questions? If not, I think we can, Alec, do you have any sort of last words, conclusions, etc.?
I'll just say how nice it is to be able to just talk like this with you all, and the questions I thought were just really challenging and provocative, and I hope I was able to answer them to your satisfaction, or at least offer some thoughts that get us some way toward answers, because I think some of your questions are just hard to answer. I just want to say one more thing about the book, Usual Cruelty. All of the royalties to Usual Cruelty are donated, so none of them go to me. They all go to an organization called the SE Justice Group, ESSIE, which organizes women who have incarcerated loved ones. So get the book if you like it, get it for friends. Also, if you are a teacher, or if you know anyone else who is a teacher or a professor, we, as Dean mentioned in the beginning, we have raised some money to give free copies of the book to every student in a class where a teacher assigns some portion of the book. And for every student who gets it, a free copy will be sent to someone in prison. So if you work with prisoners, also, we can send you boxes of the book that you can distribute people inside, or through various books to prison programs. So spread the word about the book and the ideas if you liked what we talked about today, and follow our organization on Twitter. I'm on Twitter at Equality Alec, and our organization is at Civ Rights Corps. That's it. Thank you so much for emceeing and for inviting me and for listening.
Thank you, Alec. Thank you for your presentation, the incredible stories you've shared, challenging the assumptions of this very unjust criminal system. So for all of you who are interested in Alec's book, Usual Cruelty, Boswell Books is offering a 10% discount through the rest of the month for those who attended the event today. I believe the link is also shared in the chat room. Again, thank you everyone for attending today. We're glad that you joined us. We look forward to seeing you at our future events. Next up is our May Salon with Wisconsin Assembly Representative Melissa Agard regarding marijuana policy. The event is set for May 19th at noon by Zoom, and the sign-up information will be available in our email newsletter and our website. We hope you stay safe until we see you again. Thank you, everyone. Thank you for coming, Alec, and thank you for everyone for attending.